Welcome to the June 2025 Labor and Employment Law Section Key Case Updates. I am Javier Rivera Carbone, Employment Attorney, Workplace Investigator. Today we have Thomas Sulmer from the Sulmer Law Corporation. Tom is a super lawyer, employment litigator on behalf of employees, and he concentrates his practice mainly on Fair Employment and Housing Act cases. And from the defense perspective, today I'm going to be the designated person to make the presentation on behalf or the perspective of employers. So with that introduction, being the summer, Tom, please take it away.
Thank you, Javier. I appreciate the opportunity to do this. The first case I'm going to be talking about, and the one in the most detail, is Lillian Carranza versus City of Los Angeles. This came out on May 23rd. Site is 111 Calat 5th, 388. This was a police officer with the City of Los Angeles, and she was harassed in sort of an unusual way, in that other officers within the LAPD were sharing a photograph that was essentially a nude and sexually suggestive photograph of a person who was not the plaintiff, but strongly resembled her. And the other officers were apparently sharing this in reference either that it was her or that it looked like her. This part was unclear, doesn't really matter. And she found out about it and sued the department for harassment. Case went to trial. She was awarded $1.5 million in past non-economic damages, $2.5 million in future. It was a $4 million verdict. And of course, the city appealed. And the main issue on the appeal was essentially, did this satisfy the severe and pervasive standard, the current severe and pervasive standard, which essentially means, was it enough to reasonably impact the person's ability to do their job, their sense of well-being at work, and so forth. When you get into the facts of the case, it doesn't really seem as controversial as the headline, because as it turned out, this was a rather severe example of this particular type of harassment. The plaintiff found out about it from her attorney, who was also an attorney that represented many of the other police officers as part of his assignment. And he had received information about this photograph. He didn't tell the plaintiff how he found out, but it was from one of his other officer clients. And he told her that it was being circulated widely. This ended up being very significant to the court's decision, because the city was arguing, well, she only actually found out about one specific incident where the photograph was being shared. And of course, the court pointed out, based on the evidence the jury heard, that wasn't really true. It was highly relevant that she had knowledge that it was happening on more of a widespread basis. And even to the extent it was happening in specific ways she didn't know about, that was relevant. So she finds out from her attorney. She asks for an investigation. The next thing she hears about it is a detective who's looking into it tells her, yeah, almost everybody I talk to has seen this, and people are talking about it and they're making jokes about it. The police chief testified, yes, this seems like it was being put out there in order to humiliate her, harass her, intimidate her, slander her. And it did, in fact, have that effect. When she found out about it, she was very distressed, had shortness of breath, high blood pressure, essentially had a panic attack and went to the emergency room. And in the time following, was diagnosed with, other serious psychological complications, depression, anxiety, physical symptoms related to these. And so I think the most important thing to take away from this case is that with these harassment cases and looking at whether they meet the severe and pervasive standard, it's really important to look below just sort of the headline idea that, well, this was a photograph. It wasn't even the plaintiff. She never was confronted directly by anyone. She never had anyone tell her anything to her face about it. She just heard secondhand that this was going on. So how can that be enough to be harassment? And it really is a matter of how it played out for her in this instance, how pervasive it really was. At one point, there was a watch commander who said he asked about 30 officers and 2 or 3 sergeants how many of them had seen compromising photos of department women, and more than half raised their hands. So whether that was the plaintiff or whether that was others, clearly this was a problem that was happening in the department. The other thing to note here is, in thinking about the verdict and also why the verdict was upheld, there was no discipline of any of the officers that were involved in this, even though there was ample evidence that it was investigated, that there were many, many officers found to have been involved, and that it was in fact found to be misconduct. And this is just significant for anyone practicing in this area to look at the impact of a lack of consequences, especially when the complaints are substantiated. So that's essentially the size of that one. Is yes, it was a photo of somebody else, and yes, no one ever talked to her about it, but pretty much everyone that looked into it had a very easy time finding officers that were involved in sharing this. The things they were saying were very demeaning, looking at the picture and saying things like, "Ah, I knew she was like that." And she certainly testified to how she felt knowing that was going on, and even something so simple as coming up to other officers that have their phones out, and all of a sudden they put them away very quickly, and you're wondering, what were they talking about? Were they talking about me? Were they looking at photos of me? So emphasizing and getting into those details, not just the headline facts, but the ones that are on the fringes that fill in the story, so that you really get a sense of what was happening. Hey, this wasn't a couple of people joking around. This was something, for whatever reason, became the thing to do at that particular time, and this person was targeted by it, and her verdict was upheld as a result.
I agree with Thomas that there are 2 takeaways from this case. The first being whether an isolated incident, a single event, is sufficient to create a severe and pervasive hostile work environment because of sex. And the second is that the outcome of the litigation may turn on the response of the employer if corrective action is taken as the employee finds out of the conduct. So going back to the picture, the argument that a picture that was not hers and that she only knew about personally of one incident, is that enough? And the Court of Appeals clearly says that by itself is enough because of the nature of the conduct. Even if it wasn't her, it is offensive enough, sexual enough, to only if it was the only incident, that was enough. But in this case, as Tom said, there were other incidents that created the liability for the Los Angeles Police Department. Separate from that, if the LAPD would have done something different, maybe the outcome would have been different. We don't know, and that's not part of the opinion, because the opinion concentrates on what actually happened to this female police officer at work. Tom, I would like to change now. We were talking about the LAPD on page 1 of the materials. By the way, you have access to a download of the materials in the link that comes with this video. But now looking at page 2, we move now to the Los Angeles Fire Department in the case of Cash versus City of LA on page 2. What happened in that case is that the plaintiffs filed a lawsuit. The plaintiffs prevailed, and the court gave $250,000, or there was an award for $250,000 in damages. But the plaintiff then sought from the court $750,000 in attorney's fees. And the position of the city was that the fees were excessive because there was duplication of work. They were claiming fees on top of fees, and that it was simply too much. And what the trial court did was to make a reduction of 30% across the board from the fees. It went to the Court of Appeals on the question of whether the trial court, should have looked at each individual time entry or groups of entries to determine that it was excessive billing or too much work done, or whether an across the board percentage reduction is appropriate. And what the Court of Appeal held was that the trial courts have discretion, ample discretion, to make a reduction, significant reduction in fees, even by percentage, that it does not have to, like in federal court, have a reason for each reduction, that the discretion is ample and it can be on a percentage basis. It's important to note that this was 2-1, so there was one judge that dissented. So this may make itself its way to the California Supreme Court. So this may not be the end of it, but the takeaway for all of us is that for plaintiffs, it's important that they document each of their time entries, so it justifies not only what was done, but also that eliminates the appearance of duplication or excessive work. And on the side of defendants, to look at the time entries of the plaintiffs to see if there was any duplication or excessive work, and then challenge the request for attorney's fees. Tom?
Well, yeah, I mean, if you're the plaintiff, there's no excuses. You're choosing to bring the case, so you have to play it straight all the way. That's the only way it really works. And I think that one of the sort of ancillary lessons here is not to bet on an argument that involves forcing the trial court to do a ton more work, because it's just very unlikely for the courts to endorse something like that. And an attorney who says, hey, I have 1,000 lines of billing and you can't reduce any of them unless you look at each one and tell me why, it's just not a very good argument. So I think it's not surprising that once the trial court had made findings that there was padding and that there was unnecessary work, those are the facts. The courts of appeal aren't going to disturb them. And so then the only question becomes, what's a fair way of dealing with that? And everybody understands that when we're setting the fee amount and the lodestar and the multiplier and all that, it's all in many ways a fiction. We're just trying to get reasonably close to what these things are worth. And that's why the word reasonable appears in every possible context when we're talking about awarding attorney fees. So I think certainly it's possible to see a very technical decision overturn this, to say no, they needed to do it more meticulously, but I wouldn't expect that.
I agree. And I think it's interesting to note that the final award for fees was $5,000 more than that the plaintiff got. So the attorneys got a little bit more, $5,000 more than the plaintiff. And even with the significant reduction, it's not an insignificant amount, I think.
Yeah.
So now we're going to mention a couple of cases just for the holding. And the first one we're going to mention, Tom.
This is an arbitration waiver case, another one. It's called Sanders versus Superior Court 110, Calat 5th, 1304. It's in the third page of the materials. It's a little bit straightforward, except in a couple of ways that the context of this came up, because it wasn't the initial deposit. It was the deposit for the actual final arbitration here. And for whatever reason, in this instance, JAMS had sent the request for that several months before the hearing. Now, I've read the JAMS rules generally, And often there's also something sent out at the beginning when the arbitrator is assigned. And typically that'll say that the fees for the final hearing aren't due until 30 days before that. It wasn't mentioned in the opinion whether there was a conflicting indication of that nature. But I've certainly seen it where there's a difference between the rules that the arbitrator initially gives and what appears on an invoice. And so if there's anything novel in here to consider, it would appear to be that the invoice controls, because the court said, well, the invoice said payable upon receipt. And that means that it was due immediately. And that means that as soon as 30 days have gone by, that's considered a breach of the agreement and a waiver, and it can go back into court. The other issue the court spent some time discussing is, of course, just on FAA preemption. Does the FAA preempt this rule? The court said, no, this is a procedural rule. And regardless, this is a rule that is in favor of the purpose of arbitration. So it actually is consistent with the purposes of the FAA to make sure that parties, once they've agreed to arbitration, go through with
it. I agree with your analysis, Tom, and I think it's important to note that in arbitration, usually the invoice that is the invoice before the hearing is a large invoice for employers who have to cover most of the cost or the unique cost of the arbitration. So usually it's a significant amount of money. And sometimes when that invoice is made part of the arbitration, settlement happens because the amount is a large amount usually. So this is interesting because if what happened was that they were counting on paying the invoice at some point before the hearing, but not necessarily immediately when it was sent, whenever it was sent, it's interesting, like you said. Now it's very straightforward. The Court of Appeals, at least this Court of Appeals, has said that it is due when the invoice says it's due, and if no payment is made after 30 days, that was that, no more arbitration. So the takeaway for employers, I think, is to be super careful. I don't have a different phrase than to say super careful when the invoices are due, and maybe even prepay them, and to make sure that you're not sent back to court just because an invoice was not paid. I don't think the law is going to change anytime soon. So that's what we have, and cases keep coming with invoices not being paid and people being sent back out of arbitration to court. All right. So let me just briefly mention the last case we're going to mention today, which is on page 4 of the materials, is the case of Rose versus Hobby Lobby stores. In that case, it was a PAGA case, and the employer took the case to trial. And after a 9 days bench trial, the employer prevailed. And as part of the remedies of prevailing, the employer asked for fees against the plaintiff and the LWDA. So it was a request for fees against the plaintiff and the state of California, the Labor Commissioner's Office, and the trial court gave $125,000 to the defendant employer against the state of California. Went to the Court of Appeals, and the Court of Appeals said that because the state was not a participant in the litigation, that decision of granting attorney's fees to the state was improper, and that's the holding of this case. But it's interesting from the employer's perspective that after prevailing in a PAGA case on a bench trial, it seems that it's possible for employers to get fees from the plaintiff, which is rare, to say the least. Tom?
Well, we don't know a ton about, what went down in the trial court in that trial and how weak the facts were. But some way or another, if PAGA cases are being filed in sort of a high risk, well, we'll find something kind of a way, and that becomes a matter of course. There's going to be some type of pushback where there has to be an effective way of weeding out the bad cases that isn't cost prohibitive for everyone involved. And I think that that has really been driving a lot of the politics on PAGA, and where some of the changes have been made, is that the cases are simply too expensive to defend. And that makes it difficult to distinguish between a strong case and a weak case. So, that's just something in general that we need in a civil litigation system as to any type of a claim, is, sort of controls at every point before the costs kind of spiral. I'm not surprised, again, you don't bet against the house. They're asking for the state to pay money back. I don't think that was likely to happen. But in terms of courts' willingness to order costs in employment cases, I think that's something we could certainly see happening. And definitely, if that impression, continues to get out there, that maybe there's, too many of these cases being pushed because the nuisance value has gone up simply because the cost of defense has gone up.
I agree with your analysis. I just find it fascinating because this was not a slam dunk. I mean, 9 days before a judge, there was a lot of evidence and explanation that happened. So this is not like the employer prevailed really quickly and then the case was completely without any merit. So it was interesting to see that in this case, the employer was able to get fees. And going after the state, my opinion, an overreach, but the court agreed that it was an overreach.
Right. But you know what? It's a pocket. That's the bigger pocket. Those are the ones you reach for.
I hear you. I hear you.
It's worth it.
So with that, this is the end of our key case updates for the cases decided during the month of May 2025. Please join the section meeting for July. The section meeting is going to be on arbitration, which is, this case is probably going to be part of that, and the enforcement of arbitration agreements in particular, with all of the nuances on how to enforce an arbitration agreement and the case law that has been developing in the last year. Thank you so much, Thomas. Thank you, everybody, for your attention. I'll see you soon at the live in-person meeting.